Any mention?
Yes, please, Your Lordship. My Lord, I beg to make a mention for item number 18 and 19, connected matters. On behalf of conducting counsel El Krimus out of station, my Lord.
You are appearing for
Respondent number 5, Lordship.
both the matters.
Both matters. No objection. The main topic.
When do you want it?
After 2 weeks, Your Lordship.
Respect for the learner council appearing with the number 7. This is matter after 2 weeks. Yes.
Oblige.
Oblige.
Please, Lordship, I beg to make a joint mention of item number 6, Lordship. So this matter, Lordship, this
is pending before the DB.
Lordship.
This is order passed with this court to
Lordship.
wait for that thing.
Lordship.
Okay. Yes. Submitted. The learner council appearing with the parties submit that the connected matter pending the division bench. Pending before the division bench is yet to be disposed of. In view of the submission, this is matter after
3 weeks, Lordship.
3 weeks will do after when the matter before division bench is coming up.
Lordship, most probably next week, Lordship.
Okay. In view of the bench, this is matter after 3 weeks. Yes.
Deeply obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 15, Your Lordship. I have taken the consent from the other side. Let it come after 2 weeks, Your Lordship.
My Lord, I have no objections.
Respect for the petitioner, this is matter after
2 weeks, Your Lordship. Highly obliged.
Deeply obliged.
Let me, Lordship. Item number 12, my Lord.
yes.
This is that same issue, my Lord, which is pending before the Honorable Division Bench.
Yes, respect for the council for the petitioner, this is 3 weeks.
Yes, my Lord. My Lord, I beg to mention item number 10 also, my Lord.
Yes.
I may pray, my Lord, this matter may come after 3 weeks, my Lord.
Lordship, yes.
No problem.
No problem.
Oblige, Lordship.
Okay. Yes, respect for by the learner council for the petitioner and not objected by the learned DG appearing for the state respondents. So this matter after 3 weeks.
Obliged.
My Lord, I beg to mention item number 13, my Lord.
Item
13, my Lord.
yes.
My Lord, it may be listed after 2 weeks, my Lord.
This also petition at the request of the petition list after 2 weeks. Yes. Deeply agreed.
Please, Your Lordship. Lordship, I beg to make a mention of item number 8, Your Lordship. Lordship, I pray if this matter may be listed after 2 weeks, Your Lordship.
What is this?
The chicken curry matter, my lords. The chicken curry matter.
Sure. You are appearing for the petitioner here?
Yes, my lords. The conducting counsel, Mr. K.P. Bhattacharjee, is on.
Why you are asking for time this matter?
Some more time may be given, Your Lordship, to prepare the matter, Your Lordship.
It was hard. This is 2017 matter. Okay, yes. You have any objection?
No, no, my lords.
Please for on behalf of the respondents and not objected to by the learned counsel for the petition, and this is matter after
2 weeks, Your Lordship.
yes.
Obliged, my lords.
Obliged, Your Lordship.
My Lord, item number 7, my Lord.
Why you are mentioning in piecemeal?
My Lord. My Lord, item number 7 and item number 9, my Lord. I'm praying if these 2 matters may be listed after 3 weeks, my Lord. Mr. Paul is not available, my Lord, for 2 days.
Yes, Mr. Day.
Mr. Paul has some genuine reason.
He's on bereavement.
My Lord.
Item 7?
And item number 9.
Item 7 and item 9. Same order, straightforward. Yes.
Obliged, ma'am. Item number 1.
Lordship, item number 2 is pending before the division bench.
So why it is here pending here then? If it is a
Lordship,
submission-
this is a single bench matter. They have challenged the 7th part of the high level committee constitution, Your Lordship. But the
No,
matter,
but if the division bench matter is decided, that will definitely conclusively.
yes, Your Lordship.
Then why you are keeping it pending then?
My lord, the hearing has not been not come up, my lord, probably.
No, you see, if it is totally dependent on the matter pending before the division bench,
Oh, my lord, this is we are not. Not
No,
in
no.
this.
you are not there.
We were not there.
See, Mr. Sulai, on last occasion also none appeared. We will dismiss this matter.
Lordship, yes.
None appears for the petitioner. Okay. On 27/11/2000, on 27/11/2024 also, there is no representation for the petitioner. It appears that the petitioner has lost interest to pursue this matter. Accordingly, the matter stands dismissed for default.
Apply, Your Lordship.
Item number 3.
Yes.
May it please your lordship. Lordship, we are entering appearance of this matter. I'm appearing on behalf of J. Shilla, advocate for respondents, lordship. Kindly fix this matter for hearing after 2 weeks. And we will file our wakalatnama in the course of the day.
Service is gone complete, Mr.
My
Sulai.
lord, yes. Your lordship, can you have the order dated 9/12/2024?
Yes. There are two
As per-
respondents only.
Yes, my lord, to respond. My lord, you have the limited issues only.
Mr. J. Shilla has already entered it.
Yes, yes, lordship.
Now, what is your prayer today?
Lordship, I'm entering appearance on behalf of Mr. J. Shilla, advocate for respondents.
That is, you see, you do not have to appear on the behalf of Mr. J. Shilla. J. Shilla has already appeared on behalf of the respondents, isn't it? Now, what you want today? You want it to be adjourned today? Or, see, this is a revision, isn't it?
My lord, is a review.
What for? You have the challenges.
My lord, actually,
What do you
my
have
lord,
challenged here?
the only the limited issue, my lord, is here is because of the non-listing of the matter, my lord, for a long period of years.
Yes.
Lordship, here in the year 2007, my mother instituted a suit against the respondents. Then, my lord, in the year 2014, my evidence was recorded, and thereafter, my lord, the suit was last posted on 16/3/2021.
You have come against order passed in a transfer case.
My lord, yes. Your lordships, here I filed a revision under provision of section
Why
order
your
6 and
prayer for
7.
transfer was refused over?
My lord, yes.
Why?
My lord, here the only ground was that the delay in disposal of a suit is not a ground to transfer the matter.
That is correct. That appears to be correct.
No, my
What is
lord,
wrong in it?
yes.
What is wrong in it?
No, my lord, here my only grievance, my lord, is the non-listing of the matter, my lord. Since the year 2021, the suit was never posted, was never listed by the village court.
No, we'll pass this order to list it and hear it.
My lord.
But this cannot be a ground for transfer.
My lord,
You
yes.
could have moved for expeditious proceeding.
Your lordship, yes, always the court has the power to always pass such orders. Your lordship, since Mr. J. Shilla is not here, your lordships can hear the matter on the next date.
Order of pendency
My lord.
cannot be a ground until and unless you say there is an absence of presiding officer. Presiding officer is not here.
Yes.
That is not
My
your
lord, the
case.
suit was decided by the village court, my lord.
That is okay, but then it is not that the matter is not taken up because of absence of presiding officer here.
You see, my lord, no reasons was stated as to why the suit was never taken up.
Anyway, what do you want today?
Lordship, kindly fix the matter.
Shall
for
we
hearing
dispose it
after
off?
2 weeks.
No. When do you want it?
After 2 weeks. Lordship.
My lord.
As straightforward. The Atlantic Council for the respondent number 1 and 2. List this matter after 2 weeks. If it is small matter, we can finish it. You see, why should we keep this thing?
Only limited issue. All right.
Lordship, right.
Item number 4.
Yes, another revision.
Yes, Your Lordship. We have taken step, Your Lordship, to serve the notice on December itself.
Yes, service report has not come.
No.
verify
May we
this?
file a status report in Your Lordship?
Yes. The landed council for the petitioner submits. That step has been taken for service of notice upon the Respondent number upon the sole respondent, is
Yes,
it?
Your Lordship, sole respondent.
Stop. The related office note indicates that a report of service is still awaited. Stop. The petitioner shall verify the status of service. Petitioner shall verify the status and file a service affidavit. Just after 2 weeks.
Much obliged, Your Lordship.
Item number 5.
Please, Lordship. As for the order dated 10/12/2024, Lordship, my learned friends for respondent number 4 and 5 supposed to bring an instruction, Your Lordship.
What is this matter about, Mr.
This is matter regarding because the case for restoration, petition for restoration. The case was dismissed on default. Yes, Lordship.
My lord, may kindly produce the order dated 10/12/2024.
Yes.
10/12/2024. 24, yes. Yes, what is your instruction, Mr. Day?
My lord, the proper documents was not supplied to me, my lord. So if the proper documents can be supplied to me within a 1 day or 2 days, my lord, I will.
Yes.
It's just Mr. Sangma who has to supply me a document.
So what about Mr. The counsel for the respondent one, Mr. Sangresh has had appeared, and that was his. He produced some documents. So which document you did not get? Which is not proper document?
By the PT Sangmas, my lord. Mr. Sangma has not.
Why you are not
No, Your Lordship, actually.
But then why this order is passed in a miscase? If it is a disposed matter, if it is a for restoration,
it is a restoration. Now there is a
condemnation of delay. The miscase is for condemnation of delay, Lordship. Only the miscase is listed to be.
Now the
but
case.
Then why these things are needed here?
The case was this, my lord, that who is enjoying the office of NOCMA at present, my lord. That has to be verified.
So you want to say that matter has become infructuous. Do you want to say that?
My lord, I have no stand at present, my lord, unless the main matter is argued. Here, my lord, only I was.
See, Mr. Dave, the situation here is that a matter is to dismissed for default.
Yes, my lord.
And a restoration application is filed along with the condemnation.
My lord.
Now, right now we are there with the condemnation.
My lord.
What this instruction has to do with the condemnation application?
Because here, my lord, Mr. Sangresu, my lord, he has objected to the restoration.
Is it? So that is, what is your ground of objection? Do you want to say that, you see, restoration of the matter will be meaningless? Do you want to say something like that?
Actually, Lordship, this is the second round of litigation, Lordship. Earlier also they have come, and it was also withdrawn with liberty to file a fresh, Lordship. And again, Lordship, the same ground was placed, Lordship, in the petition.
No, but then can we decide it in the condemnation application? This is not to be raised in a condemnation application. This you can raise when we consider the merit in the merit petition, if at all the matter is restored. So what do you have to do with this? But then there appears to be an order by this court, and Mr. Day has to take instruction.
Exactly, Lordship.
That is okay, but then you do not know, then you have made the court to pass that order.
No, my lord, I was directed, my lord. It is not my plea, my lord. I was directed. So if Mr. Sangma give me, my lord, within 2 days, I will take the instruction.
Let's say I'll supply actually.
It is submitted by Mr. Day.
After 1 week.
That
After 2 weeks.
No.
The petitioner, you are the petitioner, isn't it?
Yes.
I'm put up petition, Lordship. Yes, Lordship.
Yes,
petitioner has to supply.
The petitioner has not supplied him the documents as required by the order dated 10/12/2024 of this court, and in that view of the matter, he is unable to take necessary instruction. Mr. Sangma, P.T. Sangma, Lawyer Counsel acting for the petitioner submits that he will supply the necessary document within 2 days. We will supply necessary documents within 2 days. Okay. Then how long will it take to take instruction?
My lord, only 1 week will be enough for me, my lord. Let it come up on 25th, my lord.
Why are you fixing a date? If you're fixing, we'll have it after 2 weeks. It's okay, we'll have it after a week then.
After a week, my lord, the difficulty I will be
Then we'll have
going to
2 weeks.
Prayagraj, my lord.
After 2 weeks.
Lordship, Lordship.
Let's stop. Let's pray for the parties. This is matter after 2 weeks.
Much praise, Lordship.
Hearing item number 11.
Yes.
I'm sorry. This is the Balpakram matter, my lord, where the only issue in the first preliminary issues.
Lordship, actually, Mr. Hassan is the leading counsel, my lord.
Yes, where is he? He's not here. You have no instruction?
No, Lordship.
Go verify before we shall.
No, actually, my lord, he will do the matter.
He is ready to.
Lordship.
So they have filed an applications, my lord. They have filed a preliminary objections, my lord. In the preliminary objections, they have raised an issue of res judicata, which, my lord, we have answered to the res judicata. We are saying that this is not barred by.
This is pending for consideration of the preliminary objection, or
yes, my lord. Yes.
So why it is in the hearing thing then? Should have been.
My lord, no, but it was we have since this my lord, without calling for the affidavit, my lord, it has gone to the hearing portion, because initially it was thought, my lord, it is a small issue that can be dealt with, my lord, without an affidavit, my lord. But today,
is there any order passed by this court saying that there will be preliminary hearing?
No, there's no order. There's no order.
That is, you can one way it is assume it is final hearing.
It is, but
not only on the question of the admissibility.
Yes, a final hearing in the sense, but without affidavit in opposition's been called for, my lord.
Affidavit in opposition has
not been called for, my lord. So, my lord, in my humble submissions, my lord, there are at least 3 documents, my lord, passed by the officers, their own officers, my lord, which gives me a fresh course of actions, my lord. And I am banking on the fresh course of actions, my lord. So, of course, my lord, then the Guwahati High Court my lord, has passed an order saying that we have come in too late in a day, and whereas we could have invoked Section 18 of the Land Acquisitions Act, which we have not done, and we have come to the writ court. We have invoked the jurisdiction of the writ court in a very belated stage. Therefore, I'm not going to entertain. So that was a subject matter which was closed, my lord, at that point of time, my lord.
That was a decision by a single bench.
That was a decision by the single bench.
Was there any appeal against that?
No, there was no appeal. But, my lord, what had happened?
That order attained finality.
That attained in one way, it has attained finality, my lord. So that order come to an end, my lord. I am not aggrieved as such by that particular order as such, my lord. But the thing is that the issue, my lord, the deprivations of my legitimate right, my lord, I mean, like the right amount of compensation that I was supposed to, that issue remained, my lord. Therefore, I file a.
You say your claim was rejected by the High Court.
No, the claim was not rejected, my lord, on merits, my lord. It was rejected on technicalities only.
Whatever it is, if it is barred, then stands as rejected. If you are barred from raising that claim,
my lord,
that amounts to rejection. What else?
My lord, there was an my lord, while dismissing my petition, my lord, the court, my lord, at that point of time, my lord. So subsequently, my lord, we file our representations, my lord. Our representations were acted on the basis of a High Court's order. This court's order only, my lord.
Where is the earlier order? Just show us.
Page 16, my lord. May have a look at page 16, my lord.
There is no affidavit filed by the state.
No, my lord.
It is not required to be filed, Mr. Shan.
What was called for was an affidavit on the question of maintainability.
But the matter has come up for hearing.
My lord.
Lordships will recall this was already heard, and Lordships was satisfied that on maintainability their case suffers. So, which is why on merit no affidavit was called till today.
Then should have been listed for actually.
Lordship.
My lord, so as on today it stands,
The
my
matter
lord.
was already heard. We were required to file a written submissions.
The counsel earlier appeared was Mr. on the last round of litigation. I've seen the order. The order of the previous round of litigation at page 13.
Yeah,
This case was not from my chamber, isn't it? Sure. This is only the name of the counsel. So Mr. E.V. Sangma appeared here.
My lord, this is of
I
2000.
hope that this court did not have any hand in it.
My lord, I don't have any idea because at that relevant point in time,
Can you verify it? There should not be any blame there.
It should not be, my lord. We have.
Though, of course.
We don't know about the other side, but we have, my lord, full trust on my lords. So,
no, I don't suppose there's any conflict of interest.
Yes. So, my lord, as on today, my lord, as I was just saying, my lord, there are at least three orders passed by their officers, which gives me a fresh cause of action.
Perhaps let us first lead the earlier litigation. The order passed in the earlier round of litigation.
Yes, my lord. My lord, once the earlier order passed by this court, where
your claim was
rejected.
He is rejected because of the
delay
and latches on you.
Yes, my lord. My lord, that is in page 14 is the page 14 is the cause title. My lord, as a judgment before justice. I'm sorry, this is not the one. I'm sorry.
Yes. There appears to be many other cases.
Yes. Page 18 onwards, my lord. Page 17, sorry. Page 17 onwards, my lord.
That is page 16 here, anyway.
Page.
Mr. Justice Bhaipi, isn't it? T. Bhaipi, isn't it?
Yes, sir.
My lord, yes. Yes. Page 16, then come to page 17, my lord.
Yes.
Page 17, my lord. Paragraph 2 onwards, my lord.
Yes.
In WPC number 315 SH of.
You were a petitioner. In the
Yes. We are a petitioner.
In which petition?
315, my lord. 315. 315.
Yes. All right. Yes.
In my lord, in WPC number 315 SH of 2002, the petitioner is an association of Nokmas of the Aking land situated in South Garo Hills, Meghalaya, and is registered under the Societies Registration Act 1860, white registration number so and so. In the year 1985-86, the state government, for the purpose of setting up Balpakram National Park, acquired/proposed to acquire said Aking lands in 7 phases. In the first phase, 10 Aking lands with an estimated area of 220 square kilometers were acquired at a cost of rupees 3.63 crores at the rate of 1.65 lakhs per square kilometer. Again, in the year 1991-92, another area of Aking land estimated to be 76.25 square kilometer was acquired at a cost of 1.26 crores at the rate 1.6 lakhs per square kilometer. Thereafter, in the year 1994, an additional Aking land of 15.5 square kilometer was acquired at a cost of 25.69 lakhs and was handed over to the Forest Department on 19/4/1994. Again, in the following year, that is 95, another Aking land measuring 39.91 square kilometer were acquired for rupees 65.85 lakhs at the rate of rupees 1.6 lakh per square kilometer. In this manner, a total of 352 square kilometer have been acquired till 95-96. However, in the year 1996, an additional Aking land measuring 114.85 square kilometer was sought to be acquired from the 8 Akings for the purpose of expansion of the park. It is the case of the petitioner that except for this 114.85 square kilometer of land, no proper land acquisition proceedings were initiated apart from issuing notifications purportedly under sections 4 and 6 of the Land Acquisition Act, and that the unsuspecting illiterate Nokmas were made to sign on blank papers which were made out to agreements. they were never informed of the right to receive money under protest or of their entitlement to higher compensation in the absence of adequate compensation. Moreover, according to the petitioner, in assessing the rate of compensation, the respondents totally ignored the rate fixed by Garo Hills Autonomous District Council and paid rupees 1.65 lakhs per square kilometer, which worked out to be a mere 200 per biga while determining the quantum of compensation. The value of standing tree, crops, minerals, deposits, etc. were not taken into consideration. Solution was not paid, ignoring the provisions of the Act. Now, from the own pleadings of the petitioner, it becomes obvious that the landowners represented by it are aggrieved by the quantum of compensation awarded to them between 91-92 and 95-96. In my opinion, it is now too late in the day to challenge the award made some 7 to 15 years before. However, if the petitioner is really aggrieved by the quantum of compensation so awarded, it had the remedy under section 18 of the Act for reference by the collector to the Land Acquisition Court, provided that it was filed within a period of limitation prescribed thereunder. Having not done so, the writ petition, in so far as 352 square kilometer is concerned, is barred by non-exhaustion of an alternative statutory remedy. As for, so we can skip this one because 114 was not taken into consideration, and then it was not acquired also.
Now, this present case is with regard to this 11485. It has not been.
No,
that has not been never been acquired.
No, 1145.
It relate to the 352.
Yes, my lord. So, my lord may just come back to why the court did not entertain my writ. The court says that because I did not exhaust the alternative remedy. My lord may kindly come back and read again. Moreover, if the petitioner is really aggrieved by the quantum of compensation so awarded, it had the remedy under section 18 of the Act for reference by the collector to the Land Acquisition Court, provided that it was filed within the limitation prescribed. Having not done so, the writ petition, in so far as 352 square kilometers is concerned, is barred by non-exhaustion of alternative remedy. The writ was barred for non-exhaustion of the alternative remedy. That is the only point that negated against me. Non-exhaustion.
Writ was barred.
The writ was barred, my lord.
Yes.
But my right to claim was not barred, my lord. The writ was barred. So, my lord,
the writ was barred. Why? The writ was not what? Which way it makes a difference? Your right was not barred and writ was.
The writ was barred for non-exhaustion.
Your right was barred.
No, the writ was barred for non-exhaustion of my alternative remedy. But the issue, my grievances remained. It was not touched. High Court did not go, his lordship did not go into the merits.
Because that is because writ was not maintainable. It was barred.
We'll continue, my lord, after some. I think that division will continue also.
If that be the thing, it appears to be very simple. You do not have anything. How can you agitate the issue again in a writ jurisdiction?
Thereafter, I exhaustion.
My lord.
Also, cause of action cannot be revived.
No. My lord, in my humble submission, my lord, I like to differentiate it with my lord, because it's not a revival of a cause of action, my lord. It's not a revival, my lord. The cause, my grievances was there. but they have created a new cause of action for me, my lord. That is my point.
See, if once a matter stands judicially determined,
Yes, yes.
can that issue be tasked again by the executive authority?
In,
That is what you have to say.
yes, my lord. My lord. All right.
11,
Yes, Mr. Even. Yes.
My lord, it's very difficult for me to say, but I've been instructed by my clients, my lord, because it appears that they were watching over my the live streaming, so they have got information. They instructed me because one of the counsel who were their counsel was from your office, my lord. So they was asking me, my lord.
But then that doesn't bar me
That
until unless
100% doesn't bar. That's
but
why I
then
said
you have any trust deficit then.
my lord, not me, my lord, my clients. Well,
I can understand.
I have full trust, my lord. That's why I said I have a very difficult because in my almost a decade of practice, I have never.
See, this court also had not noticed earlier
My
the
lord.
name of that counsel.
My
The
lord.
fact remains that he was attached to me till the
My
day
lord,
of my election.
my lord. So my clients were saying that because they because all small society they know each other very well. They said no, they come from there.
So they thought that is a difficult court. So get rid of it.
Not exactly. So I have that much instructions, my lord. I'm so sorry, my lord. To you.
That's all right. This is matter for any other virtue. Where is Mr. Sam?
He's on next Marat court room number 1.
But there is no problem.
I've informed him to my lord. I've informed Mr. Sam about that.
We were in the midst of the hearing.
My
not
lord,
at the end of the hearing.
I'm so I.
No, it's all
I
right.
have no words to.
We can understand. We can understand.
My lord, very difficult situations I will put, my lord.
This is matter before any other virtue.
I'm deeply obliged.
Right, my name. Right.
item number 14.
After so many days, after it was hard, quite
My
some
lord,
occasions.
my lord, yes, my lord. We have put a lot of effort in this.
That's all.
All right.
Your Lordship, the conducted counsel has encountered some personal difficulties and is unable to present today. May I humbly request that this matter be fixed for hearing on another day within this week? On another day within this week, Your Lordship.
It will go to next week, not this week.
2 weeks, after 2 weeks, Your Lordship.
Yes, you yourself you were saying.
Yes, they were
showing
pressing for,
urgency.
yes.
Okay, just say. Desperate for why? MS so and so appearing on behalf of Mr. A.R. Pasal, learned counsel for the petitioner. This is a matter of 2 weeks. Over.
Pleasure, Lordship.